Good afternoon, everyone, and hello to all of those online. I'm very pleased to be moderating this panel 7 on coordinating the implementation of secured transactions reform at a regional level with a special focus on gender. So the purpose of this panel, obviously from the title, is twofold. One is to consider secured transactions reforms that are happening at the regional level, and then we're trying to look at this also through a gender perspective. I propose 2 options to the panelists to consider these separately in 2 rounds, or to give each panelist an opportunity to present in one go, and they preferred this latter option. So we're going to begin with a global overview of women's financial inclusion, and then move through the other panelists who will present from their regional perspectives. So we have 1 panelist in person, and then we have 3 online. And do we have all online? Yes, we do. Okay, very good. So I think also because James had mentioned to me yesterday that he felt like an unknown among knowns, and that made me rather sad. So I hope at the end of the conference, you're going to feel like a known among knowns. So I'd like to introduce each of our panelists, and I will do that individually and then invite them to take the floor. So first of all, we are going to hear from, and I should also mention that unfortunately, Andy Woolnough, who was going to be speaking on behalf of the Women's World Banking, unfortunately has a case of COVID, but he has very graciously arranged for his colleague, Dr. Sonja Kelly, to speak on his behalf. So we have her online, as I understand, and so I will introduce her now. She is the Director for Research and Advocacy. She's the global lead for Women's World Banking Research. Through research on the financial sector, policy trends, financial services providers, and end users, Sonja and her team advocate for women's financial inclusion. Before joining Women's World Banking, she advised the U.S. Department of State on strategy for U.S. embassy engagement in digital finance around the world. She has served as the Director of Research at the Center for Financial Inclusion at Action, has held consulting roles at the World Bank and at the Consultative Group to Assist the Poor, called CJUP, and has worked in microfinance at Opportunity International. Sonja holds a PhD in international relations, and her dissertation focused on financial inclusion policy and regulation. So she has a PowerPoint presentation for us, so I will turn it over to Sonja, please.
Thank you so much, Jeannette, and thanks to this community and the organizers for the kind invitation to Women's World Banking to speak. Jeannette, you've been so helpful in organizing us, and it's a real pleasure to be with my fellow panelists, Mike, Pilar, and James. Actually, Mike Dennis was the one who introduced me to this topic 3 years ago at the State Department cafeteria when we had an informational conversation. And of course, Charlotte, who's in the conference, is taking forward that work. So it's a real pleasure to be among friends. I get this, hang on one second. There's a note that the host disabled participants screen sharing. I wonder if you can give me permission to screen share, or I think you have my slides, so you can go ahead and present. But while you're figuring that out on your end, I have the great pleasure and easy job of sort of setting the stage for our conversation as a group on coordinating the implementation of secured transactions reforms at a regional level, and with this special focus on gender. And I've been really pleased to hear the conversations that have been happening thank you, I just got a screen share permission. The conversations that have been happening here on implementation. And I think it seems like because of the great work of this group, the legal underpinnings of secured transaction reform have been really solid. But these challenges related to implementation on the government capacity side, on the financial services provider side, and on the customer side are really really mysterious ones, and ones where we're asking a lot of whys and trying to understand what's happening there. And hopefully Women's World Banking's focus on end users, and especially women, might lend some insight into solving some of those challenges. So I'm sharing my screen. I'm hoping that if you can't see it, that somebody will jump in and tell me. I'll start by talking a little bit about the background for the need for capital and inclusion among women entrepreneurs, and centering our conversation on the actual need. Then I'll go into talking about 3 lending innovations that work for women that we've been keeping an eye on or engaging in. And then I'll pass it on to my panelists to give my fellow panelists to give the regional context here. So Women's World Banking, if you're not familiar with us, just very quickly, we've been around for about 40 years, and we do work in a lot of different areas with the end goal of women's security and prosperity. And we think that the best way to pursue that security and prosperity is through women's financial inclusion. So we invest in financial services providers who are doing that work. We help other financial services providers in our network to build the right products. We advocate for policies with policymakers and regulators around the world, but especially in our top priority markets, to try to affect change at the policy level. And then I do research on all of these things, providing the evidence base for our work. So we have new data from the World Bank Global Findex, which you may have seen. We know that globally there are 742 million women outside of the formal financial system, and there's a further 250 million women who have accounts that have not been used in the past year. We at Women's World Banking, we did some very simple analysis on this country level data to look at if current trends continue, if the current trajectory in many of these countries where there's the largest gap between women and men's financial inclusion, if current trends continue, how long it's going to be until we see gender parity in financial access. In Nigeria, it'll be over 100 years, and that's not the country with the most egregious gap in women's and men's financial inclusion. In Algeria, 109 years. In El Salvador, 46 years. And so this really is an area, women's financial inclusion, that deserves a lot of attention and focus. And we did, on this data, we also did another simple exercise related to credit. The survey, and this is a nationally representative survey of almost every country in the world, the survey asked people, have you borrowed any money in the past year? And you can see in the blue bar the percent of people who say they borrowed any money in the past year. So in Uganda, it's almost 80% of women who say that they borrowed money in the past year. And then on the orange bar here, comparatively, you can see the percent of people who borrowed from formal sources. And those formal sources are quite inclusive, basically means any regulated formal source. So it's a bank or a microfinance institution, or in some cases, a cooperative. There are lots of different formal ways that people borrow. And then we did a quick back of the envelope calculation and looked at the number of people the gap between the orange bar and the blue bar represent. If the average loan size in the informal sector is $100, this is a missed women's market opportunity of $68 billion. Turning to women-owned MSMEs and MSMEs generally, we know that there are 131 million formal MSMEs in developing countries that have unmet financing needs. This equates to a $5 trillion finance gap. And women-owned businesses account for 32% of this gap. Women-owned businesses are big contributors to global and national economies, but they struggle to access capital. And when you add up that unmet credit need for women entrepreneurs, it's about $1.7 trillion. The barriers that we find at Women's World Banking that we're actively working to to counteract in our policy advocacy are, one, the challenges related to women's lack of identification. Women are almost twice as likely to lack a formal identification. There are, in 60% of countries, there are legal discriminations between a woman's and a man's access to credit, according to the World Bank. Also, according to the World Bank, 40% of countries limit women's property rights. We find that even in those countries that don't have limitations to women's property rights, the way that the properties are titled might actually be disadvantageous to women. So, for example, if there's a convention that a man's name comes first on the property title, and the credit bureaus only have space for one name when they evaluate creditworthiness, it might still disadvantage women, even if there's not a de jure limit to women's property rights. And finally, women own less than 20% of the world's land. So really, in this conversation, setting the stage, the summary is women are at a distinct disadvantage, and innovations in lending have the potential to really make finance work for women in a way that the financial system hasn't worked for women in the past. So I'll talk about 3 lending innovations that we're tracking. One is, it's like silly to even put the title of this slide up here, but movable collateral. And we looked this year at 3 examples of movable collateral registries enabling credit to women. And in fact, I'll put that in the chat in this conversation in case you're watching the chat or online. So I just put that publication in the chat. We found that there are some great examples that I'm sure have been cited the last couple days, or I know have been cited, of countries that have really promising movable collateral systems. In Colombia, in 4 years between the beginning of the registry and a survey, the percent of firms that reported access to credit as their biggest challenge changed from 33% in 2014 to only 7.5%, reporting access to finance as their biggest challenge after the registry was implemented, and nearly half of SMEs in Colombia are owned by women. In Ghana, we see a lot of promise for women as well, where women make up 40% of all registrations on the registry and account for $100 million in financing that have been extended using the registry. So this is very promising from our perspective. However, there are some challenges that our case studies revealed and other work that we've done reveals, and these have been cited in this forum as well. First of all, kind of a headline that's not on the slide is issues related to gender disaggregated data. We don't actually know with many of the registries what percent of the registries are women or what percent of assets are owned by women. One of the challenges that we've found in talking to credit bureaus is the challenge between ownership that's individual and ownership that's a business. And obviously a business, you can't cite the gender of the business. And so that's an issue with tracking and reporting sex disaggregated data. We also find some challenges related to low budgets in government agencies. We highlight in this report that I just put into the chat, let me show you here. We highlight the fee structure of collateral registries because we have a hypothesis that this is a big driver of actual government capacity to pay salaries. And the example of Mexico that we looked at, where use of the registry is quite low, we actually did a bit of mystery shopping where we had some people try to register assets on the registry and didn't find very good customer service. And in Mexico, the registry is free. In comparison, other more successful registries have some kind of a fee associated with the use of the registry that's fairly nominal for the size of a business that might be using the registry. But probably our hypothesis is, and this is not something that we've done representative research on, but The research we do have indicates that government capacity is largely driven by budgets, and charging for use of the registry ends up creating the ability of an institution to fund itself. We also see low buy-in from financial services providers around the world where we've looked at registries. Our conversation with Mexican financial institutions found that they actively try to avoid using the registry, often because of the staff time necessary to register assets on the system. They describe a very manual process of downloading an Excel spreadsheet, filling out the Excel spreadsheet, then uploading it to the right place, and then there might be some back and forth with the way that things are formatted. And these challenges for financial institutions really disincentivize active use. The same institutions we talked to in Mexico also expressed concern that the legal system wouldn't be easy to navigate or cost effective to navigate in the case of seizure of an asset. And then finally, low knowledge among women entrepreneurs. Research in Ghana, conducted by or funded by USAID, found that many people applying for credit didn't know to ask about registering assets on the registry, and the financial services providers that they worked with did not actively volunteer this information. This was the case in our research in Mexico as well, that you see pictured here. Personally, I would really like to do some mystery shopping research across a number of countries in this space to explore those consumer side challenges to registries. Let me highlight very quickly two additional, and I do mean very quickly, two additional innovations that we've seen. One is digital credit. There's a growing wealth of data in the world and new computing power, new models that are emerging. And whereas 10 years ago, digital credit models were only dispersing very small values, for example, $5 in emerging markets, now we see digital credit getting into funding for SMEs and using things like inventory or lists of customers and those kinds of assets on which to lend. So here's how it works. All credit applications are processed online or through a smartphone, so low cost of entry. The applicant gives permission for a financial services provider, in this case, our partner Lending Cart, to access their data on alternative information such as e-commerce activity as an indicator of inventory and transaction volume, business growth, inventory tracking systems, and more. And then these alternative data points create thousands of variables on which an institution can make decisions on lending. And as the institution grows, their algorithms become only more accurate. And I'll give one more example of an innovation, and that's on person-to-person lending. One of our investee companies, Amartha in Indonesia, is a platform that connects borrowers to lenders and reduces information asymmetries. And this is an unsecured transaction, but I think there are things we can learn from this. In particular, the institution is providing information on a business, and in many cases validating that information. So providing information on their inventory or the size of their customer base, the type of institution it is, and then they can find a peer lender somewhere out there in the market. Amartha in Indonesia is highly successful with a 99% repayment rate. And this to us is as well solving some of the challenges that secured transaction reforms are trying to solve. And so it's something that we're actively watching. So I'll stop there and really interested to hear these things contextualized in what my colleagues have to share, and then we can get into a discussion. Back to you, Jeannette.
Thank you very much, Sonja, and nice to meet you virtually. Perhaps one day we will meet in person. You've set out very nicely for us the stage for the situation for the women face in terms of accessing credit. What I have personally found working sometimes in the political arena is that there will be many government officials and people who are aware of the need for access to credit, particularly for women, and will speak to that. And then at the same time, one can approach and say, well, may I speak to you then on secured transactions reform? And you get this sort of the eyes glaze over. I'm sure you've all been in that same situation. So there's these two camps, those who work in the area perhaps where Sonja and Andy have been working, and then those working in the secured transactions reform world. And sometimes it seems as if the two worlds don't meet. And so let's see now how the relationship is to the area of secured transactions reforms. And we'll turn first. We're going to look at different regions now. And first, we'll have an example at the country level from East Africa, Kenya. So let me introduce our next speaker, Mr. James Kashangaki. I hope I got that right. Has worked for over 20 years in the financial sector in both the developing and developed world, with a growing focus on expanding access, inclusion, and use of finance by making financial markets work for the less fortunate in society. He has extensive knowledge of conditions in developing markets, particularly in East and Southern Africa. James began his work with the Financial Sector Deepening Trust of Kenya, or FSD Kenya for short, in 2006. Over the years, his role in the organization has grown, and in 2019, he was appointed to his current role as Chief Program Officer. In that role, he has responsibility for the delivery of projects in financial sector policy and infrastructure, finance for agriculture and processing, climate smart results, health and affordable housing, as well as trade. During the COVID pandemic, his advice was solicited from various government departments on mitigation policy for MSMEs. James has an MBA in finance from the University of Rochester, an MPA in international economic policy from Columbia, and is also a certified executive coach. I give you the floor.
Thank you very much, Jeannette. And thanks to the organizers of this conference for thinking of us in Africa to invite us to. I've really enjoyed the 2 days. I've gotten a lot of context for my interactions with secured transactions. I just guess a little bit about the background of FSD so you know where we're coming from. FSD was formed in 2001 as a department within, then it was called the Department for International Development. Now it's called FCDO. It moved to the Foreign and Commonwealth Development Office. In 2005, it was hived off from DFID and became a registered Kenyan trust, independent of DFID, but funded by DFID. As an instrument originally for donor coordination, because there are lots of donors who were doing work in the financial sector, and the people at the time thought that it would be good to have one vehicle to do that work. People weren't tripping over each other. It didn't work, but we have been consistently funded since then by Gates Foundation, DFID to a certain level, and FCDO, and the Swedish SIDA. So we're not currently in our 5th strategy, 2022 to 2026, and that strategy at its core is about gender, MSMEs, green, and digital. Our mandate is to catalyze the financial market to develop sustainable solutions that add real value to the Kenyan population at large, and specifically many SMEs, smallholder farmers, and low-income households, many female-headed households. I should note that on income, Kenya has a population of 50 million. 20 million adults, approximately. The median adult income in Kenya is $50 a month. So you have to think about that in the context of what is possible in the realm of financial inclusion. So the emphasis on providing real value in financial inclusion, or real inclusion, because we recognized over time that increased financial inclusion and access does not automatically translate into reduction in poverty. And it shows itself clearly in our statistics. In 2006, financial inclusion stood at 26%. Financial access and inclusion stood at 26% of the adult population. In 2022, it stands at 86%. So 86% of Kenyans have some access to the formal financial sector. And yet poverty levels are still grinding. And so we had to ask ourselves the question, why? It's not just about access, it's not just about usage, but it's about the appropriateness of the financial solutions that are developed. And therefore, we have to change the way we do the development of financial solutions. So when I was thinking about this, I mean, there's a lot I could talk about. There's a huge amount I could talk about, but I do think that in relation to what we've been talking about the past 2 days, it makes sense that I give a kind of history of our involvement in secured transactions regime, so you can understand the difficulties that I was trying to bring out in my question in the last presentation. But I'll just go through the chronology and then bring out some of the statistics and results from our work. In 2007, after I just joined FSD, I was charged with, well, I was basically given a check and said, here's some money, go develop SME finance in Kenya, and good luck. In the course of my trying to develop a project, and I talked to a lot of people, I realized that it didn't matter what you were concentrating on. We did a lot of let's explore warehouse receipts, or all the things that we've been talking about here, leasing or whatever. You know, let's explore whether we can get that into the market, because there was none of it. The basic foundation on which all of those products rest didn't exist. And one of the problems that we ran into constantly was that banks were only willing to accept real collateral. So only willing to accept buildings and land as collateral. And it was an extraordinary process to get those perfected. And so I thought of, well, why don't we do a study of how much it costs, how much it adds to the cost of a loan, to collateralize these loans. And so I wrote the TOR in 2007, but I was not going to do it alone. I didn't want to be the guinea pig. I needed to get someone in the government, and more specifically the central bank, to work with us. And that process of getting the central bank to agree to changing the TORs, making them happy, took 3 years. We finally did the study and launched it in 2010. And it can be found on our website, the cost of collateralization in Kenya. I think I would recommend that anybody who's getting into this field should read that, because that was the basis for beginning the journey. And then after the launch, and the PS said he was going to form a committee, and we were going to have, you know, and the minister was there, and the central bank governor, the thing went into hiding and sat, as the previous speaker said, for a further 3 years. I kept pestering, wondering what was happening. You know, that was my job. I kept the pressure on. In another piece of work that we were doing, we were helping the Treasury to develop the financial sector's medium-term plan for Vision 2030, which is Kenya's going to be this excellent country in 2030 with everything going right and everything well. The financial sector had its part to play, and the medium-term plan is a 5-year plan. And everything from that 2010 study was put into the second medium-term plan as an objective for the Treasury. Out of the blue, I mean, they just pulled it out and said, all these 15 recommendations are going in there. And all of them had to do some way with, and that was the start of a journey that involved the World Bank coming in and helping us out. And they provided a consultant who was called Marek. And that's when I first met Marek. Why I asked the question I asked in the last panel was, are you frustrated by your the setup? FSD Kenya has always had a very flexible funding mechanism. So we're given a pot of money, the donors expect some results, and they allow us to go play. And I think that's I mean, obviously it's a lot of accountability, a lot of trust, but they give us that ability to change, to pivot, to do things. And so when Marek comes and says, these guys need something, or, you know, or somebody comes and says, the people who are in charge of the registry come and say they need something, we can turn and we can find some small funding to do various things. And so the journey from 2014 to 2017, when the law was finally passed, was one which Marek can give his opinion on. It was a journey of pulling teeth and being denigrated, and the law was pulled apart. Number of stakeholders grew by the day. All people who didn't want it, lawyers, and because they were all making money out of this system that existed before. And so but there was a will in government because it was in the medium-term plan and they needed to have some results. And so by luck and grit and having Marek guiding the process, I don't know how many times I took him to various game parks and retreats around Kenya to help cajole and talk to people. We finally got it passed in 2017. And then it sat. And it was the perfect law from the model law that has been passed, and it sat and sat and sat. There was slight movement. One thing I forgot to say was that in deciding to build the registry, the minister wanted points from the doing business I think the World Bank has done away with now, but then it was big, and Kenya wanted to be up there on the doing business, so they built a registry on top of a payment system. And of course, that registry didn't have anything to do with the law, but it had several functions that could be called a registry, and in technical details Marek can go into with you. But we got this registry, we got the act, and then things kind of died down. Every once in a while, there'd be questions from us to the people involved. Do you want capacity building? Do you need help? World Bank do you have any more money? Can we do something? We did several assessments of the registry to give impetus to the fact that it needed to be corrected, and so on. And okay, so I would say that that whole process has landed us where we are today, where there is a new government in Kenya. There is political will to do something for MSMEs. Big, huge. It's absolutely at the top of the agenda. And therefore, they're turning to everything that can help. And of course, we're getting calls to kind of give our opinion about what can happen. And I think last week we went with Marek to Mombasa to train judges on secured transactions. Most of them had never heard of it. And it's been on the books for 5 years. But I will say that there are about 10,000 registrations happening a month without any thousands of registrations against livestock and crops. 1/3 of all registrations are against local companies, which means that something is sinking in. 1/3 of registrations are foreign companies, and many registrations, a significant number of registrations are for women, are against women, particularly in the trade area, because they're largely the traders. The final point on evolution of our credit work, we've done work in bureaus and credit guarantees as well. But realizing the government's fiscal constraints, we can't keep setting up agencies and registries and telling the government they have to do this. But we take lessons from South Africa, which has an overarching credit regulator. And we're thinking that that's a possible direction for Kenya to go. And we'd like to get somebody in government interested in bringing together all the disparate things to do with credit and have one regulator. I'll leave it there. If there are questions, I'll be happy to answer them. I know it wasn't about women in particular, but we're all about gender. So thank you for listening.
Thank you very much, James. And you have illustrated, I think, what was mentioned in the last panel, the amount of time that these things take. You know, that we expect things to change overnight, and it just doesn't happen. And of course, now we're going to turn to another area of the world, to Latin America, and I'm going to introduce our next speaker. Dr. Maria del Pilar is an attorney and public notary with a doctorate from the Autónoma University of Barcelona. She has practiced professionally for over 20 years in corporate commercial law, particularly in secured transactions, leasing, factoring, and financial structures. Currently as an international consultant, she has worked with the Inter-American Development Bank, the OAS, which is where I met her. We worked together on projects, the Development Bank for Latin America, the World Bank Group, and the U.S. Department of Treasury Office of Technical Assistance, has experience in El Salvador, Costa Rica, Mexico, Peru, and a number of other countries. She's represented Guatemala at UNCITRAL in the working groups on security interests, insolvency, and MSMEs. Maria del Pilar also teaches and is head of the corporate law and financial systems at Universidad Francisco Marroquín Law School in Guatemala. Maria, you are online now and you have the floor.
Thank you very much, Jeannette, and I will share my screen to so I would like to confirm with you first if I move the presentation to see, is it running correctly?
Yes, it does. We can see it. Thank you.
Thank you very much, Jeannette. So first of all, I would like to congratulate UNIDROIT, UNCITRAL, OAS, and all organizers for making possible this important conference, and especially for giving me the opportunity to contribute to it. Also, I'm very happy to see many friends. It's sad that it was not possible for me to attend it in person, but I hope it will be possible next time. So today, I will share with you some personal thoughts and ideas about financial inclusion and women in the context of secure finance reform, focusing on Latin America, where I've been working the last 15 years. Let's see. In many countries, women face various barriers in accessing finance. Such barriers can range from discriminative legal rules to the fact that in many rural areas in Latin America, the mother is the head of the family and the main provider. In most of the cases, lack of access to education is the major underlying cause for discrimination against women. Several studies show that there are more loans granted to women than to men in the field of microfinance. Women are good borrowers. Only 1% default, according to a study carried out in El Salvador. It was exactly the work I did with Jeannette a few years ago. However, when it comes to small businesses, women stop to asking for loans, and a much higher percent of borrowers are men. For example, recent release data shows that more women-led businesses closed temporarily compared to those led by men during the COVID-19 pandemic. This is due to the fact that women have fewer opportunities to grow from micro to small business because of the inverse relationship between credit level, amount, and women's access to credit. One of the main reasons of that, however, is lack of awareness or knowledge as to how women can market themselves as good borrowers. Such knowledge is, of course, acquired by education. Probably, if women were better aware of their rights and able to effectively market their worthiness, financial institutions will be more inclined to include women in their credit portfolios. This is particularly correct in the area of secure transactions. However, it is interesting to see what has been going on in this region, especially in Central America, where many financial institutions now are focusing on products for women. Now, let's take a look of these scenarios. Let's see country A, where family law provides that a married person has 50% of the property of the family. Jose, the husband of Maria, goes to the bank and asks for a credit and offers his vehicle as collateral. Let's assume that later Jose defaults on the loan and the bank seizes the vehicle in accordance with the loan agreement signed by Jose and the bank. Even though Maria owns 50% of the vehicle, she never expressed her consent or objection to the transaction, and bank therefore can rely on only 50% of the vehicle, not on her part, or because women in country A, including Maria, do not possess such knowledge, they practically cannot proceed with claiming their rights. What is the result of this situation? Maria did not participate in the loan process and decision-making. Maria does not even know she had 50% ownership share in the vehicle that has illegally lost to the bank. The bank relies illegally on 100% of the vehicle, and the bank has no interest to empower Maria because anyway, she will not claim her right. Now, let's see country B, where there is a woman's right awareness policy implemented through a range of public educational activities. The bank knows that women in country B are likely aware of their rights and could insist on protecting them. The bank is also familiar with the rules of family law, which are similar to the ones in country A. When Jose goes to ask for a loan from a bank and offers the vehicle as a collateral, in order to reduce risk, the bank will ask if he is married, and in such case, it will seek Maria's consent also, that must be informed and willful. Maria's consent must be informed and willful, and the bank will make sure it obtains that information by informing Maria all the details of the loan agreement, including the implications of default, and will seek her consent independently of any influence. Then it's willful. What is the result? Maria is included in the processing of the loan transaction by the bank. She is aware of her 50% ownership right in the vehicle and therefore can agree or object to the transaction, and of course, reduces risk of default by including her considerations for the long terms and considerations. The bank is actively involved with the process of empowering Maria as it reduces the risk of default. Now, logically, in country B, the banking supervisory authority is more likely to seek to ensure that the credit agreement rely, among other things, on informed and willful consent of Maria than the authority of country A. This is a result of a higher level of awareness and practice in country B regarding protecting women's property rights and the understanding that such policy is not only the right thing to do, but also economically justified. So, policy of awareness of women's rights can result in a faster and sustainable positive impact in women financial inclusion in countries where the legal basis and rules of women protections are in existence already. What is needed is to tackle the barriers through empowering of women with education and awareness of their rights, a policy that could make an enormous impact in Latin American countries like Guatemala and the rest of countries. I will share some information with you now. So let's see what has been happening in Latin America the last 20 years. You can see in this table some of the countries that have done the reform. I divided them in 3 groups. The first group that is marked with pink is the countries that did some kind of reform between 2000 and 2015. We can see Mexico, Guatemala, Honduras, El Salvador, Peru, and Costa Rica. Peru was the first country that did the reform in 2006. Mexico doesn't have a secure transactions law, but they have done a very important reform in their commercial laws, so they have adopted the main principles of secure transactions. And of course, they have a very good secure transactions registry. From the countries that did the reform in this first stage, only 2 of them have done a second round reform, that is Guatemala and Peru. Then in the second stage is only 1 country, that is Colombia. Colombia did a very important reform in 2016 with a very successful registry. The third group of countries are the ones that have not adopted yet a secure transactions law, but they're in the process of doing it. These countries are the Dominican Republic and Paraguay. In the case of the Dominican Republic, they adopted the secure transactions law in 2020, and it will come into effect next January. In the case of Paraguay, they don't have secure transactions law yet, but they have a factoring law and they created the factoring registry in that law, and they created it in a way that it will become a full secure transactions registry when the law will be approved. Currently, the draft is already in the Congress, and we expect it to be approved in the next months. So we can see that countries completed the reform, but the more important and the key thing I want to show is that all of them created an electronic registry, which could be one of the main vehicles to promote women's rights. I'm not entering into the tricks, bells and whistles that make this happen, but speak now in general and not in technical terms, this could be a good tool. We have to remember that publicity and transparency are two of the main features of modern secure financial systems, can promote public awareness with the ultimate result of women inclusion during the process of credit granting. The conclusions are, in order to eliminate barriers to access to finance for women, especially in regions like Latin America, where despite of existence of more egalitarian laws, many girls and women do not have access to sufficient education and are from a very young age heads of family. A policy of awareness of their rights could be an effective strategy to protect women and promote policies that allow them to grow economically.
Thank you very much, Maria Pilar.
One more conclusion.
Oh, sorry.
Secure finance reform can be one of the more effective avenues to include women to larger extent in the economy, if such reform takes into account natural and legislated rights of women and reflect such rights in the design and operation of the law, of the regulations, and the registry. Now I finished. Thank you very much, Jeannette.
Thank you, Maria. And I apologize for jumping in. There was a long pause there, and I'd assumed you were finished. But that was very interesting. And indeed, what you have illustrated so well with your examples, with your theoretical examples, as well as the actual summaries that you've given us with these number of countries in the region, is this need for capacity building, once again. And it connects very well with what James had said, is that access to credit alone does not necessarily reduce poverty levels. So the connection there in terms of the need for awareness raising at various levels and the complexity of capacity building at various levels in the process, as has been mentioned in the previous panel, I think this theme really comes through. So then let me introduce now our next panelist. Last but not least, Mr. Mike Dennis is a private international law consultant. He serves currently as a legal consultant to the APEC Economic Committee and the World Bank on implementation of private international law reforms. He developed the administrative implementation work plan and the related proposal for an ODR satellite website for the APEC ODR collaborative framework that has recently been implemented by APEC. He was previously with the U.S. Department of State, where he served as the U.S. representative to UNCITRAL and headed the U.S. delegation on several matters, including arbitration, ODR, secured transactions, and leasing. He serves as a U.S. expert on various international groups, including as an observer to UNIDROIT Working Group on Model Law and Warehouse Receipts. He has published widely on human rights and private international law. Recently, he has co-authored a study on the effect of the COVID pandemic on secured lending reform and access to credit in APEC economies. Mike, you have the floor, please.
Good afternoon, everyone. Can everyone hear me?
Yes, we can hear you well. Thank you.
Great, thanks. Let me share my slides here. Let's go with that. Doesn't, is it, there we go. Thanks, Jeannette, for the introduction, and thanks for the excellent presentations from Sonja, James, and Pilar. It's a privilege to be able to address this conference. Today, I'd like to give an overview of the regional coordination of secure transaction reform in APEC. Merrick and I have worked on private international law consultants to APEC for the last 3 years on secure transaction reform projects sponsored by the U.S. We've worked closely with the U.S. Department of State project overseer, Joseph Donahue, as well as Charlotte Tramhel from the Office of Legal Advisor. Let's start with a few APEC facts. APEC represents 40% of the world's population, 50% of the world's trade, and 60% of the world's gross national product. A key pillar of APEC is the Economic Committee, or EC. The EC engages in structural reform. The World Bank, UNIDROIT, UNCITRAL, and the Hague Conference have standing invitations and regularly attend APEC EC meetings, policy dialogues, and workshops. The APEC Business Advisory Council, ABAC, also regularly attends APEC EC events and collaborates closely with the EC. Chris Waller heads up a secure transaction implementation plan, and you heard from him earlier today. The EC implements secure transaction reform through 2 subgroups, strengthening the economic legal infrastructure, CELI, and ease of doing business, EODB. CELI is a sub-fund financed by Hong Kong, China that pays for capacity building work to help APEC economies strengthen their legal infrastructure. APEC uses the sub-fund for workshops and studies on CELI legal reforms, including secure transactions. APEC Ease of Doing Business is sponsored by the US. It's based on 5 elements from the World Bank Ease of Doing Business. The 3rd action plan set an APEC-wide target of 12% improvement in the 5 priority areas by 2025. The World Bank is now transitioning from ease of doing business to a business enabling environment, or BEE, which includes a new financial service element. The financial service element adds 4 new components to the doing business, getting credit topic. It's my understanding that the quality of the regulations index for secure transactions would remain the same. If the index criteria were to change, this conference should have some input on any future index that might be developed. APEC leaders have called for economies to implement ease of doing business and secure transaction reform to unlock the economic potential of MSMEs. There's still a huge finite gap for MSMEs in many APEC economies. The EC has performed various activities to promote secure transaction reform, including workshop, policy dialogues, technical assistance projects, and a diagnostic of APEC member economies laws that Merrick conducted. The 2018 workshop in Mexico City was co-sponsored by the World Bank, included over 80 participants from 14 economies, along with the World Bank, UNCITRAL, and UNIDROIT. Following the workshop, the Philippines received technical assistance to implement its new law on secure transactions. The law was drafted by Merrick with IFC assistance. The law is compatible with UNCITRAL standards, but the Parliament included some notable exceptions. Merrick also drafted a law on warehouse receipts, which has not yet been adopted. In 2019, CELI hosted a policy dialogue within the APEC EC plenary meeting where Jason Lee from UNCITRAL, Will from UNIDROIT, and John Wilson from the World Bank highlighted key instruments for secure transaction reform. And last May, the US sponsored a hybrid workshop in Tokyo on modernizing secure transactions legal regimes in APEC economies through international instruments and effective dispute resolution. The workshop included 80 participants from APEC economies, along with UNCITRAL, UNIDROIT, and the World Bank. The workshop addressed how APEC economies, particularly developing economies, can improve their legal and regulatory infrastructure to enhance access to credit by implementing the UNCITRAL and UNIDROIT standards. The workshop also addressed women entrepreneur needs and extending the availability of online dispute resolution mechanisms. The workshop was based partly on a study on issues affecting the implementation of secured lending reform and access to credit due to the COVID-19 pandemic in APEC economies. And Merrick and I co-authored the study and the workshop report. Here you see the 2020 World Bank Doing Business Legal Rights Index for APEC, showing the level of secure transaction reform in APEC economies. It serves as the starting point for the third APEC Ease of Doing Business Action Plan, and this index will continue under BEE. Overall, APEC had 4 economies rank in the top 5 in the world on access to credit index. New Zealand and Brunei ranked number 1, and Australia and the US tied for number 5. Several APEC economies have enacted secure transaction reform in the last 2 years, as highlighted in our study and workshop report. Just to summarize briefly, Peru, as Pilar mentioned, and the Philippines have reformed their secure transaction frameworks. The reforms improve substantive rules governing secure transactions, registry implementation, and laws on critical credit products such as factoring. Malaysia and Vietnam are working on new laws and changes to existing frameworks. And Japan and the Republic of Korea have made strides towards reforming their secure transaction systems, spearheaded by the relevant ministries. China has successfully made reforms in its secure transaction framework concerning factoring. This chart shows how APEC economies stack up to other regions. None of the regions rank well concerning secure transaction reform, but APEC came out on top with an average ranking of 8.1 out of 12 in the Legal Rights Index. The next APEC events will be a study sponsored by the US and a follow-up workshop in Tokyo in May of 2023. The study and workshop will discuss the similar and distinct challenges faced by civil and common law jurisdictions when implementing international standards on secured transactions, particularly the UNCITRAL model law. It's based on recommendations from the May 2022 workshop, and the project is co-sponsored by Indonesia, Japan, Papua New Guinea, and Vietnam. As discussed at the workshop, transfers of ownership and possessory pledges characterize civil law systems. In contrast, common law systems have established registration systems for some types of encumbrances, such as charges of company assets. Historically, civil law systems have been reluctant to permit extrajudicial remedies, many of which have been recognized by common law jurisdictions for decades. Many common law economies have already implemented or are contemplating reforms, such as Malaysia, and some are embarking on second stage reforms, such as the United States. Civil code provisions that deal with core concepts such as proprietary interest are harder to amend. However, several APEC civil law economies have recently reformed their secure transaction law using techniques such as 1, adopting standalone comprehensive legislation, for example, Brunei; 2, addressing the main issues and laws and regulations, such as the Philippines; or 3, adopting multiple acts to deal with specific issues concerning secured transactions, such as registration, for example, Vietnam. Other civil law APEC economies are considering reforms, such as Japan and Indonesia. Let's now look at gender finance in APEC, and this was also addressed in our study. APEC leaders have prioritized improving gender finance, as demonstrated by the La Serena Roadmap for Women and Inclusive Growth. The APEC Women and Economy Dashboard 2021 reports a steady improvement in economies concerning women's access to credit. The dashboard 2021 found that laws in most APEC economies have consistently protected women's rights to property and inheritance, but women's access to credit remains constrained by creditors' discrimination based on gender. As the World Bank Knowledge Guide on Secure Transaction Reform points out, a modern secure transaction law can unlock new financing opportunities that are of particular benefit to women, empowering them to overcome the lack of title land or limitation on their power to transfer property without the consent of the husband, as is the case in certain economies. They can use the assets they have to gain access to formal credit markets. However, the Knowledge Guide stresses that implementation of a modern secure transaction regime is insufficient if women lack property rights or the power to create a security interest. It also recommends developing credit products tailored to the smaller size and informal structure of women-owned businesses and the types of assets they own. At the Women and Economy Forum last month, APEC leaders made providing women access to credit a priority. All APEC economies have established targeted financial inclusion programs to counter discrimination in women's access to credit. 18 out of 21 APEC economies have financial literacy programs that cater specifically to women. Government-linked microfinance programs used by 8 out of 10 women-led businesses have been launched in 12 economies, and technology-enabled microfinance programs are now available in 5 economies. A key recommendation from the 2018 Mexico City workshop was to establish gender-neutral access to credit frameworks. As Sonja mentioned, governments need policies to collect gender disaggregated data for financial services, including through secured lending registries, to determine the extent of informal barriers. Evidence for policy development continues to suffer because of lack of gender data. The next steps on secure transaction reform in APEC include developing a study on tailored approaches for common and civil law jurisdictions, holding a follow-up workshop next May in Tokyo, pending final approval, discussing workshop recommendations and conclusions at EC2 in the US in August 2023. This conference might suggest to CELI that the EC plenary hold another policy dialogue on secure transaction reform at EC2 to discuss the new instruments being developed by UNCITRAL and UNIDROIT, the new World Bank financial service element under BEE, and the results of the May 2023 workshop in Tokyo. Thank you for listening, and back to you, Jeannette.
Thank you very much, Mike, for that very comprehensive overview. Now, I have been told by our colleague here that we have until 4:30, so we do have time for a few questions. Do we have any questions on the online chat, Will? Or do we have any from the audience on the floor?
Jeannette, there is one in the chat from Sanaz Javadi. She says, the intersection between intellectual assets and gender inclusion is under policy debate, and I would like to know if any organizations have started working on this. I'm unable to answer, but if somebody else from the panel might be able to.
What's the question?
It's been suggested to me that I give the floor to Sanaz, who may wish to explain the question further. Yes.
Hi, hello everyone. Can you hear my voice?
Yes, we can. Please go ahead.
Yeah, thank you so much. Thank you so much for providing me the opportunity. I know that I don't have much time. I just wanted to, actually, the reason that I asked the question is because, as I mentioned in the chat box, is like the area that I'm working on. And as we are today discussing about the secure transactions and going toward digital economy and talking about metaverse and all this protection and intellectual property assets in digital environment, I would like to know if any of the panelists or speakers have done anything related to intellectual property, because I'm an intellectual property lawyer based in Geneva, Switzerland, and advisor to World Intellectual Property Organization, together with the European Union Intellectual Property Office, working with Swiss government, different governments on IP policy. And recently, since last year, WTO has also established a gender hub in order to work and provide awareness and training on diverse aspects of gender inclusion, from financial inclusion, the work from World Bank together with other UN agencies and also academia and think tanks. So I just wanted to present a little bit about what I have been doing, but I know that the time is tight, so I just wanted to provide this question. If you have included any sort of protection of IP assets under your area of work, because last year we developed a study under the funded project of European Union for the protection of women businesses and inclusion of women in international trade through effective use of intellectual property system in developing and least developed countries in Southeast Asia. And this project would be done in some other regions, including, we heard a little bit about Latin America, but I've been also invited to work a little bit on women businesses in Africa. So I would highly appreciate if you can elaborate further on this. And so for the sake of coordination, I thought it would be good to brainstorm a little bit on this aspect as well. Thank you so much for giving me the floor.
Okay, thank you very much. So I put that question to the panelists, and there may be others here in the room who might be able to address it. I also would like to take the prerogative here as moderator to put a question forward, in the sense that we are trying to look here at, in this panel as well, in terms of the relationship between work that is done regionally and at the global level with our the organizations that work internationally. So wondering about whether the role of regional organizations is to work to implement international instruments, or whether there is a role for work on instruments at the regional level as well. For example, at the OAS, there certainly is consideration once again, at the General Assembly, there have been, resolution has been to invite member states to consider strategies towards continuing with, resuming rather, work in the codification and harmonization of private international instruments. So wondering whether there is a role there. And so maybe I would put that question to Mike as well, to think when you talk about this study on the common civil law relationship in terms of secure transactions work, how do you see the role there of the APEC community? Is it to implement international instruments, or is there some work to do at a regional level? Is there enough differentiation regionally for and culturally for work to be done at a regional level in terms of developing instruments in the field? So leave maybe that question forward. I don't know if there are other questions coming forward. We do have one here from Milot Amha. Would you like to take the floor, please?
Yes, sure. And I think it's a question for maybe whoever has sort of the response from the panel. We mentioned about the sort of the disconnect maybe sometimes between the secure transactions work, but also the training on that side, especially on the gender related issues. And I would just like to say that it's the EBRD, sort of in my line of work, we've been working in Jordan. So we launched this program where we're training women entrepreneurs on property law issues, but also on access to finance issues. So we've developed this sort of comprehensive training for them, which is all online. And now we have lined up training workshops for, I think, about just short of 1,000 sort of women entrepreneurs to be trained and to be informed on these topics, essentially. And this is, I think, the first of this kind that we're doing. So I wasn't sure if maybe any other organization or any other sort of colleague was sort of involved in this type of training and how sort of they went about it.
Thank you very much. So I will turn back to our panelists to see if anyone would like to take up those three questions or any comments. I also wanted to give Sonja an opportunity, since you were the first speaker, if you wanted to reflect, given your perspective and the way that you approach these issues from your area of work, having heard the three speakers addressing secure transactions reform, if there's anything you wanted to say in terms of, is it encouraging to you what you heard?
Thanks. Yeah, well, maybe I'll just share a couple of words on that and then turn to Pilar and Mike, both who have their hands raised as well. Yes, I think when I first got into this space, when Mike and I first had coffee a number of years ago, 6 years ago or something, I thought, oh, this is so interesting, and it just seems so simple. And as I've gone deeper into understanding the relationship between legal frameworks and consumer issues, it has gotten a lot less simple and a lot more complex. And what's encouraging to me about this panel, our discussion, and the themes that I'm hearing in this conference is that there's a much more realistic sense for the patience required in this work and the challenges, given that it is such an interdependent system. I mean, James's recalling of the timeline that he's been working under, Mike's kind of litany of all of the different interrelated efforts that are happening in his work, and Pilar's discussion of sort of the complexity on the consumer facing side and what has to happen in the process is encouraging to me, because it feels like a more nuanced understanding of those complexities, that process, and the need for patience means that we're more likely to make progress. On the EBRD work, I really would love to follow up. So maybe we can, I don't know if you're connected to the chat, but maybe we can connect and share details, because that sounded really interesting. We're doing a lot of financial capability building for entrepreneurs, but not in this space. And I think that's a big opportunity to integrate that into existing financial capability and digital financial capability efforts.
Yeah, just say I'm not in the chat, but I'll get your contacts and get in touch.
Perfect. Yeah, sounds great. Thank you.
Thank you very much. I see that Maria Pilar or Pili, you have your hand up. Would you like to take the floor briefly, please?
Yes, very briefly. Related with your question, Jeannette, about the international instruments, I think they are very important, especially the model laws. I had the opportunity to work before there was the UNCITRAL model law. And since I work in Latin America, of course, OAS model law was very important for us at the beginning, because it was the only instrument we had at that point. And I could see how when we did the reform in this, let's say, first stage, it was very useful to have the UNCITRAL model law for the, let's say, second stage. Actually, now I'm working in the Dominican Republic and in Paraguay, and it was amazing to include in these laws we did in these past years many little details and technical things that were discussed in UNCITRAL that it's very important to include in the laws. Also, I want to make a little comment. Of course, these international instruments are model laws, but it's important that we adapt them to the country. Of course, it depends of the way the country organize their civil or commercial law. But for example, the best example for me of the time is Mexico. They don't have a secure transaction law, but since they have federal laws and laws that are only civil for each state, what they did is to reform the federal law, so then it will apply to all the states. So more or less, that's the idea, to use the international instruments to do a good reform, especially to respect the principles involved in such instruments, and then the country will feel more comfortable with a project that respects their own form. Thank you, Jeannette.
Thank you very much. Mike, would you like to make a few comments briefly, please?
Sure. Thanks for the excellent question. I worked on the OAS model registry regulations that followed up the OAS model law, and that was before UNCITRAL adopted a model law on secure transactions. And I think as far as developing international standards of that nature, it's best to do it at the international level. And our focus in APEC has been on implementing the UNCITRAL instruments and the UNIDROIT instruments as far as secure transactions are concerned. At the workshop that we held in 2016, it's interesting, there were two recommendations coming out of that workshop. One was on the need to develop a model law on electronic warehouse receipts, and a second was on a need to develop a multimodal instrument on electronic warehouse receipts and bills of lading. And the question was, should be that be done at the regional or should be done at the international level? And now it's both instruments are being developed at the international level. And again, I think that's the best course of action if it can be done at the international level. As far as online dispute resolution is concerned, there was no real international consensus as far as how to develop online dispute resolution. We had the UNCITRAL ODR technical notes on ODR, and so but they were just simply best practices, and they weren't really an international standard. So APEC did go ahead and develop the APEC ODR collaborative framework and the model procedure rules, and we're implementing that. And it's been quite successful. And perhaps there'll be a follow-up at the international level concerning those types of standards as well. But I think it's best to operate at the international level when you're talking about standards. As far as like the differences between civil and common law jurisdictions, this study that we're developing, again, we'll take a look at that issue. We'll publish the study, and if it's useful in other regions, perhaps something can be done at the international level in UNCITRAL or UNIDROIT. But overall, I think it's best to develop international standards at the international level through UNIDROIT and UNCITRAL. Thank you.
Thank you very much. I'm afraid we don't have any more time. We're already over the limit, so I won't be able to give you I wanted to give you a chance to maybe respond. Do you have any further comments? Okay, maybe over coffee. So may I invite you to thank our panelists, the three we had online, and James as well. Thank you. And we didn't have time to answer the question on intellectual property. I defer that to the last panel.